also laid down certain norms with respect to approaching NCLT and NCLT. If at all the insolvency proceedings are still pending, the court has made it extremely clear that till the time the COC makes the final decision on the bid, NCLT and NCLT cannot intervene. However, NCLT and NCLT can be only approached if at all there is a question of law regarding its interpretation or its usage which needs to be addressed, and that tenure, that time itself would be exempt. Would be exempt from the 270-day resolution plan, clearly paving the way for an independence for the Committee of Creditors. They will have certain degree of autonomy as far as decision on bids are concerned. Apart from that, in this particular case, the court has made it extremely clear that 66% of majority of the Committee of Creditors will have to finalize the bid, and if at all the majority does not approve of any bid, then Essar Steel will go into liquidation. The court clearly ruled that the Committee of Creditors has the authority to examine the plan on merits, while the COC had requested the court that the parties be given additional time. The court also ruled that timelines which are made according to IBC are mandatory in nature. It's also important to see that ineligible bidders don't wriggle out of clauses of IBC, and the court also observed that the management of a certain company may be a de jure fact, but the control of the same company is a de facto fact, and that also needs to be considered with respect to this particular case. And after paying the dues which are to be paid by Numetal and ArcelorMittal to become eligible for the bid, they will have a time of 8 weeks to submit their revised bid.
Right, Abhimanyu, just hold on to your thoughts. Since you were at the Supreme Court and you heard the bench pronouncing the verdict, give us a sense of what was the nature of dues linked to Numetal. We are all aware that ArcelorMittal is expected to pay the dues linked to Uttam Galva and KSS Petron, but I believe Numetal has also been asked to pay dues. Has the nature or quantum of those dues been specified by the Supreme Court, or is that unclear as of now?
The nature and quantum of the dues have not been stated in the verbal judgment. For that, of course, we will have to wait for a written copy. But nevertheless, the court has made it extremely clear that both the companies, if at all they have to become eligible for bidding, will have to pay the requisite and remaining dues, which clearly means that as of now, they are not eligible, and their eligibility is subject to the payment of the dues which is to be paid by them. As far as the possible dues by Numetal is concerned, that would only become clearer when the written copy of the judgment comes out.